Case People versus Thomas Styron. Here we go.
Welcome to Court Stream, and buckle up, because today's case is a full-blown legal roller coaster. We're diving into the courtroom drama of People versus Thomas Styron, a case that starts with identity confusion and escalates into a spiral of sovereign citizen rhetoric, legal resistance, and heated tension between defendant and judge. Right from the jump, Mr. Styron challenges the system, questioning not just the charges but his entire legal identity. Wild, right? In this explosive courtroom showdown, we'll witness repeated contempt threats, a judge desperately trying to restore order, and a defendant insistent on rejecting the authority of the court. We've got dramatic legal arguments, emotional flare-ups, and even some shocking medical revelations later on. But stay with us, because beneath the chaos is a powerful look at courtroom procedure, legal rights, and the fine line between civil disobedience and contempt. So who is Thomas Styron really? A misunderstood citizen, or a reckless legal saboteur? Stick around, it only gets messier from here.
Assistant Public Defender Otello on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that, right?
We've been through this. Seems to be some confusion.
What's the confusion?
I stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
Okay, this is where things start unraveling. Fast. Judge Simpson is clearly trying to give Mr. Styron a fair shot. He asks a basic question: do you understand the charges? But instead of a clean yes or no, Styron offers vague affirmations, and then proceeds to laugh. Let's break it down. This is a critical moment because a defendant's understanding of their charges is a legal prerequisite for moving forward. The judge needs clarity, but Styron's evasive answers and inappropriate smirks turn this into a ticking time bomb. And when the judge threatens 30 days for contempt, that's not for show. Under Michigan court rules, disruptive behavior like this can land you in jail immediately. Question for you: do you think the judge was being too harsh here, or was this courtroom behavior completely out of line? Let us know in the comments. We want to hear from the jury of public opinion.
So I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. You may need an attorney. Your fault. First calls the case of the People versus Styron. Recall.
You're compelling me to identify as Thomas Styron?
Now here we go with a textbook example of sovereign citizen rhetoric. Styron starts refusing to identify as the legal name on the case, implying that the court is attempting to create a fictional entity. What he's referencing, though without clarity, is a fringe belief system where individuals argue that the legal person created by the government is not the real them. Courts across the US have repeatedly rejected this. In legal reality, if your name appears on the arrest record and charges, you're the defendant, period. This kind of language is often used to derail or delay proceedings, but as you'll see, Judge Simpson isn't having it. He's about to shut it down hard. Watch for how the judge reestablishes order while preserving due process. It's a masterclass in courtroom control. Have you ever heard someone try this in court? Drop a comment if this blew your mind.
The legal entity on this case?
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of
man,
all,
I'm the
watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a SQV trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion?
Wow. This is Judge Simpson laying down the gavel, not just literally, but with authority. You can feel the tension spike as Styron keeps talking in circles, and the judge flat out warns more time is coming if the antics continue. Let's be real. Judges don't want to throw people in jail for contempt. It's a last resort tool, but it's crucial. Courtrooms function on order, and without it, justice can't move forward. Simpson walks a delicate line here. He allows the defendant to speak, but draws the boundary sharp and fast. This clip is a perfect study in power dynamics. One person holds the gavel, but the other is holding up the process. And that moment, you will learn how to conduct yourself. Oof. You can hear the shift in tone. The gloves are off. Would you have given him more chances, or was the judge right to threaten more time?
I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. You can go right there. For having it. Court does call the case of People State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm accused on behalf of the club.
Sir, state your name, please.
I'm George Styron II.
All right. This date time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court.
This is where things finally start getting technical. Judge Simpson outlines the 3 charges: fleeing a police officer, assaulting, resisting, obstructing an officer, and driving with a suspended license. 2 of those are felonies, not minor traffic issues. Pay close attention to the breakdown here. This is a preliminary examination, not a full trial, meaning the state only has to show probable cause, not prove guilt beyond a reasonable doubt. If they can show enough evidence that a crime likely occurred, the case gets sent to circuit court for trial. So when Styron insists on representing himself, he's now held to the same standard as a licensed attorney. That means understanding evidence law, courtroom procedures, and legal consequences. Think he's ready for that? Comment below.
You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I don't understand everything.
Okay. And sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the noon staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first video.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate it.
Here, for the first time, Styron raises a legitimate point: insufficient access to discovery materials. This is serious. If a defendant hasn't had time to review body cam footage or evidence, it could violate due process. What's wild is that Styron, who up until now has been erratic, starts making a fair procedural complaint. But even that gets buried under rambling about video counts, staff shifts, and Facebook clips. It's chaotic but rooted in something real. The system failed to ensure timely access. This is where your opinion matters. Do you think the system is partly to blame for not facilitating proper access, or is Styron using this as another delay tactic? Legal takeaway: even disruptive defendants still have constitutional rights, and the right to review evidence is non-negotiable.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
Right. I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, a count of felonious assault, which assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay.
Things just got a whole lot more serious. The prosecutor drops a bombshell: additional charges may be added, including felony assault with a dangerous weapon and felony firearm charges. And here's the kicker: each firearm charge carries a mandatory 2-year prison sentence. No wiggle room, no probation. This completely changes the stakes. What started as resisting arrest and traffic issues now escalates to a potential multi-year prison sentence. And remember, these are stackable charges. They don't replace each other, they add up. So ask yourself, if you were facing multiple felonies and guaranteed prison time if convicted, would you still try to represent yourself? Stick around, because this isn't even the final twist.
Right. And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far, and I guess that was unclear, you have access to the body cam?
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it?
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body cam, maybe 20 minutes, half hour's worth.
When you're saying his, you're saying,
Officer Hoops, yes.
okay,
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
okay, let me ask you, go ahead, were you gonna say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, this sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay,
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
gotcha.
Prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to
Yeah.
try to, okay,
Flint's definitely provided direction in regards to how I can go about getting this.
all right. Okay, so we'll need to then adjourn that. Have you, well, I'm going to ask it one or two ways. How long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it? Or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a.
No, that's fair. That's fair.
And then also,
But you don't know total. You don't know total time how much there is.
and
You
also
just know that one.
since May, I've been fighting an illness that just recently the jails addressed. So yeah, there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's making me very lethargic and
This is a surprising pivot. We go from legal argument to a medical reveal. Styron discloses that he's been urinating blood and struggling with a stomach infection since May. He claims the jail delayed his treatment and only recently prescribed antibiotics. Now this adds emotional complexity. Regardless of the charges, inmates have the right to adequate medical care. If what Styron says is true, it points to larger systemic problems within the correctional facility. But there's also strategy here. By raising medical issues during a hearing about legal access, Styron may be laying the groundwork for a potential delay or even bond release. Smart move, maybe. Genuine concern, possibly. Here's the question: should a defendant's medical condition factor into pre-trial release? Let us know in the comments.
Okay, I got you.
energy in that.
What do we
Progress
got?
that as well.
What do we look like on the 6th? Okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me?
You got all of the discovery. Like you got the, as far as you know, you got the police report, you have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th. (2024) at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything.
Judge Simpson, despite earlier frustration, grants a 3-week adjournment, and honestly, this was the right call. It shows judicial flexibility, ensuring the defendant has enough time to review evidence before trial. This is key for fairness. If Styron doesn't have access, the case could fall apart later due to procedural error. Judges have to balance courtroom efficiency with defendants' rights, and Simpson demonstrates that here, firm but fair. But there's also subtle pressure. The judge makes it very clear that if there's another delay, it better come through proper channels, not in the middle of the next hearing. This kind of exchange shows the tightrope judges walk. Give too much leeway, and justice is delayed. Give too little, and rights are denied. Comment below, did Judge Simpson strike the right balance?
Talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here telling me you're not ready. You know,
Fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to run the information and serious charges against him.
Whoa, the prosecution isn't pulling punches here. Alleging that Styron threatened to cook a police sergeant while armed takes this case into very serious territory. But wait, Styron fires back, claiming Cook referred to legal action in court. He says the body cam shows he meant to use the legal system, not violence. If that's true, this could be a major misinterpretation. The stakes couldn't be higher. The difference between threatening violence and promising a lawsuit is massive, and one carries mandatory prison time. This all comes down to context, and the body cam footage will be key. So what do you think? Could this be a misunderstanding or a serious threat dressed up in legalese? Drop your thoughts below.
Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Haupt took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said Cook, I made it very clear. Said I meant legally in the courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, he was there for a welfare check with a possible rolling domestic, which which led me being pulled over, me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who was looking up in his talent or the lane system or whatever it is they use in the police cruiser. Make sure they iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. And sorry,
Go ahead.
Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. Had no intentions of running or trying to avoid it at all. And I think my actions would suit such.
In this matter, I'm not going to at this point change your mind, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do.
Here we get the judge's reasoning for denying Styron's bond request. And it's not just the charges. Judge Simpson says it's about demeanor, how Styron has behaved in court. This matters more than most people realize. In bond hearings, a judge can weigh both the severity of charges and whether the defendant can be trusted to follow court orders. Styron's earlier outbursts, laughter, and contempt earned him a revoked bond, but today he's calmer, and the judge notices. Simpson even says today was 180 degrees from previous hearings. That's huge. So here's a question for you. Should one good court appearance be enough to reconsider bond, or does past behavior weigh more? Sound off below.
This is the first time today, as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here.
This line hits like a gavel. A lot of it is of your own doing. Judge Simpson isn't just handing out rulings, he's sending a message. Styron wants to be released, wants access to evidence, wants to represent himself, but the court reminds him his own conduct triggered many of these obstacles. From resisting identity confirmation to outbursts and delays, the consequences are stacking up. This isn't just legal, it's human. Actions have ripple effects, and in court, every moment counts. This is the emotional heart of the hearing. Accountability is key. Whether you agree with the judge or not, his tone here is firm, controlled, and ultimately fair.
Okay, and so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical, or to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts and me trying to represent myself.
Oh no.
And in regards to the medical thing, I reported this in May. It took until I got a flood in July before anything was ever followed up on or done.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. Yeah, and I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom toward this court for reasons I don't even, Mr. Siren, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
I wasn't implying that, Your Honor. What I was saying was, maybe I was misunderstood, that when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. Since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out, or I believe I came and went so fast. It wasn't even opportunities.
No, there were a couple of adjournments because of that.
Okay.
But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, I'll just be honest with you, Mr. Tyron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision.
Talk about brutal honesty. Judge Simpson straight up tells Styron, "You got a hot head. That's not an insult. It's a reality check." He explains that his hesitation in allowing Styron to represent himself came not from bias, but concern. Serious charges are on the table, and the judge wanted to be sure Styron wasn't rushing into self-representation just out of frustration or ego. This shows a rare moment of transparency. Behind the bench, judges wrestle with decisions that affect lives, and Simpson shows he's thinking not just legally, but humanly. So fair judgment or condescending tone. Let us know where you stand.
Just because, and not fully understanding what this was, because these are serious charges and there potentially more that are coming. That's my whole thing on that. Okay,
I appreciate it.
all
One
right.
last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything that I can. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
Perfect, because envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send to everybody.
They're $1? Seriously?
No, down there.
I got about $500 in back. That. Okay.
So
Why? No, I'm just saying, if I can sell it for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
perfect. Thank you.
Okay,
Yeah.
Mr. Syra? I appreciate you behaving yourself this way. Because just listen, because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. All the other judges have ever had one front of whether Miss Fink was able to have a conversation after the court time.
She's nicer than I am.
She's a very nice woman, that's for sure. And
She's much nicer than I am.
like I
And
say,
so
maybe-
she has patience. Sometimes I don't.
fair enough.
So you got to take it as it is. All right.
Well, have a good
Thank
day.
you. You do the same.
Thank you.
And that's a wrap on one of the most chaotic, intense, and emotionally charged hearings we've ever covered on CourtStream. From legal identity debates and courtroom outbursts to serious felony charges and health concerns, the case of Thomas Styron is a masterclass in courtroom tension. Judge Simpson balanced authority and fairness, while the defendant walked the tightrope of legal rights and erratic behavior. The court's refusal to grant bond for now reflects not just the charges but the courtroom conduct and the looming threat of additional charges. That's going to change everything at trial. Let's hear from you. Is Styron misunderstood or a danger to public safety? Should he represent himself or get legal counsel? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.